Hey, it's Terry Gorry, and this is the Irish Law and Small Business podcast. So there's an interesting personal injury case there that I came across the other day. It's to do with a woman who says that she hurt her back while changing a baby's nappy on the Croke Park floor. She obviously was part of her case would have been to do with the baby changing facilities and so on in Croke Park, but there's some important principles that you can actually learn from this case, especially if you're considering bringing a personal injury case yourself, or indeed if you are the recipient of a personal injury summons or a claim against you. The woman claimed she'd hurt her back because she had to change her baby's nappy on what she described as paper napkins on a dirty toilet floor due to the absence of baby changing facilities. The judge was told in the circuit court that the woman, Therese O'Boyle of Ashbourne, was not only abandoning her case but agreed to make a contribution towards the legal costs of Croke Park, which had appealed a €15,000 District Court award in her favour. The court was told that O'Boyle had wrenched her back and neck while lifting her 2.5-year-old daughter off the floor. Judge McCourt, he asked her legal team where was the alleged negligence on the part of Croke Park. And that's a question that you always have to ask, whether you're bringing a claim or defending a claim. Is there negligence? Is there liability? Is somebody to blame, or was it just an unfortunate accident? In order to win this claim, this lady would have to prove that Croke Park were somehow negligent. So let's just see, were they negligent? Barrister for Croke Park said that there was not only one but a number of other baby changing facilities available in the stands, and told the court that there was no legal requirement on anyone to provide baby changing facilities anywhere. And that is the legal position. Judge McCourt immediately invited the parties to discuss the matter outside court. Within minutes, the judge was told by Miss O'Boyle that, or by her legal team, that she was withdrawing her claim and would make a contribution towards Croke Park's legal costs. O'Boyle had told the lower court, that's the district court, while attending the August 2018 match, she had asked 2 staff members about baby changing facilities, and they had told her they did not know where they were. Another had told her she did not think there were any such facilities in the arena. Eventually, she had been forced to lay her baby down on paper napkins on a dirty toilet floor to change her nappy, and had wrenched her back and neck when lifting the child off the floor. So this was either an unfortunate accident or it was negligence on behalf of Croke Park. And the judge correctly asked the legal team for the lady, on what basis were you alleging or claiming negligence against Croke Park? The district court judge, after hearing Miss O'Boyle's evidence, had ruled that there had been negligence on the part of Croke Park, and after studying medical reports awarded her $15,000, which is the full jurisdiction of the district court and costs. So she got the top end of the jurisdiction of the district court. The case was appealed then by solicitors for Croke Park. They stated in the full defence, that any incident at the stadium on the day of the match had been due to the acts of Miss O'Boyle and not by any negligent act or wrongdoing on the part of Croke Park. Miss O'Boyle had disclosed in her proceedings that she had not had any previous injury claims, but in 2016 had brought a civil suit against Paddy Power Unlimited for unsolicited emails, a case that had been settled out of court. Following the withdrawal and the cost contribution by O'Boyle, a spokesperson for Croke Park and its insurers, Allianz, stated there were 13 baby changing facilities within the stadium in both female and male restrooms. The bottom line is, from a personal injury perspective, the one principle you must look at and take from this is that you must, in order to win a personal injury claim, prove negligence. If you cannot prove negligence, if you cannot point a finger at somebody and say they are liable, they were negligent, they are responsible for my injuries and the loss that I've suffered. If you can't prove that, well then your personal injury claim will fail. You must prove negligence. I've made videos before about it. People think that, oh, I had an accident in work, or I had an accident walking down the street, or I had an accident at a park or a creche or something, or a play area for kids. That's unfortunate, but sometimes accidents happen. Sometimes nobody is responsible, nobody is liable, nobody is negligent. If you're going to win a personal injury claim, you will have to prove negligence, assuming that the other party puts in a defence and fights the case. They may not do so because it may be, from a strategic point of view and a cost point of view, more sensible simply to accept that the likelihood is the respondent will be found liable in negligence and will have to pay. So that's why you will see a lot of claims being settled. A lot of respondents simply don't want to run the risk of going to court, fighting a case, having negligence found against them, finding themselves liable, and then having to pay out costs plus obviously the award. Hope you find this video useful. If you do, I would appreciate if you gave it the thumbs up down below. Thanks a lot. And you may be interested in subscribing to my YouTube channel. If you are, hit the subscribe button down below on YouTube and hit the bell icon on YouTube, and you'll be notified every time I make a new video. Thanks a lot.